So today's topic is foreign patent and trademark filings, the strategies and insights. Firstly, I would just like to understand how many of them belong to the legal background and having some kind of interest in IPR. Probably explain, the difference between patents, trademarks, copyrights, and so on and so forth. So just to begin with, just a brief description of what is intellectual property. So IPR are legally recognized exclusive rights to creation of the mind. So intellectual property is generally divided into a couple of things like patents, trademarks, copyrights, design registrations, and geographical indications. So which is basically inventions, which is literary and artistic work, which is designs, symbols, names and images used in commerce and trade. It is an intangible asset for any individual or organization. Tangible is something that you can touch and see and feel. Intangible is something which is there in the mind. It's the creation of the mind. You cannot touch and you cannot feel, you cannot see it, but it's there in the mind. It's the creation of a artist. It's the creation of a R&D person or technology, something like that. As I said, the different kinds of IP, starting with patents, trademarks. So I'll just give you a brief, glimpse of what is different IP. Patent is for the inventions, for the innovations. It has to pass the three tests of novelty, inventive step, and industrial applicability. If something is technologically driven, something that is innovative, that falls under the patent domain. Trademark is generally for the company name, logo, color combination, sound mark. That's falling under the trademark. Copyright is for the literary work, artistic work, dramatic work, musical work, sound recording, cinematographic work, so on and so forth. Industrial design is merely the look and appearance of the product or the shape. So basically the color combination will not matter, only the shape and appearance will matter. The dimensions will not matter, but only, for example, the Bisleri bottle. Bisleri bottle is very different from the Kinley bottle, which is very different from the Coca-Cola bottle. So all this is protected under the industrial design. Only the mere shape and appearance, the look of the product is protected. Geographical indication is distinctive of a particular region. Like for example, Kolhapuri chappals. Everybody is aware about Kolhapuri chappal. Because it is originating from a certain region, the artisans of that particular region have certain kind of expertise to produce that product. And that's why geographical indication is only oriented to a particular region. No one person can hold a geographical indication. It's a community as a whole. It is a group. It is a regional people that make up to the geographical indication. For example, the Rasgulla of Odisha. So West Bengal and Odisha were fighting for a long time that who wants the geographical indication of Rasgulla, but then finally Odisha won. So that's the thing. Something called as trade secrets. Trade secret is not very prevalent in India, but it's the confidential proprietary knowledge which is not in any kind of public domain. That is called as trade secret. The recipe of Coca-Cola, only 3 people in the world, they know about the recipe of Coca-Cola. And they pass on in a certain manner that if one person dies, then only the other person is entitled to know that particular knowledge, which is a confidential information. In India, we can of course protect confidential information in the form of agreement or kind of NDA or MOU with strict provisions under the law. So these are the various kinds of IP. We will focus majorly on patents and trademarks, starting with trademarks and the foreign filings and the scope of it. So this is the 5 things that we are going to do today. That's the gist of the whole, webinar today. Foreign filings of trademark under the Madrid Convention, foreign filing of patent, Paris Convention and the PCT, procedure and timelines for the Paris Convention and PCT, recent trends in trademark and patent filing in foreign countries, and the strategies to file the foreign application. So the general question is, why have we chosen foreign filing? So a lot of my clients, they come up to me and they say that they want a world patent. So there is nothing called as a world patent or a world trademark. IP rights are territorial in nature. So be it patent or be it trademark, wherever your commercial interest lies, you need to file the IP in that particular region. So as you know, a lot of MNCs are filing it in India, because they see some kind of commercial value, they see some interest, they see some benefits of filing that particular IP in India. There is a market for the same, and that's the reason they are filing. For classic examples is McDonald's, Coca-Cola. These are the MNC brands. They have registered their IP globally, not just India, but globally. So Coming to trademarks, there are different kinds of trademarks. We'll not go into much detail, but just to give you a glimpse, for example, this McDonald M, the color yellow is protected for that. Also the M part. So on highways, if you see from far away that the M sign is there, you understand immediately that it's McDonald's and you need to stop if you want to eat a burger. So that's the power of trademark. Any common local person, from even from the rural area nowadays understand McDonald's, because it has penetrated so much deep into the market right now that Coca-Cola, everybody understands Coca-Cola. That particular font of Coca-Cola is also registered as a trademark. Tata is again a Indian company, but doing business extremely well in India, is also a well-known trademark in India. Coming to patents, everybody must be aware about this kind of glasses. So Snapchat, everybody knew Snapchat as just an application or some kind of a social media platform. But Snapchat has filed 282 patent applications for, different technologies. One of them is the camera-laden sunglass for capturing video. So they have a button kind of thing wherein basically the video recording starts and it's directly integrated to a mobile phone. So, all these foreign companies are filing IP in India because they see some kind of value in filing IP in that particular geography. Who can file the foreign patent trademark application? It could be any Indian national, be it like a student, researcher, small scale entity, startup, business organization, anybody who has an innovation or who has a trademark or who has some kind of commercial value that they see, they can file any kind of foreign application, be it in any geography. So I'm not saying that you file it globally, but wherever the commercial interest lies, you need to file in that particular region. So for example, there is a commercial interest in US, you need to file it in the US. If there's a commercial interest in EP, Europe, you need to file it in that particular region. So finding out those particular regions is very important, and then you proceed for filing the applications. When can the trademark application be filed outside India? So there are two things. One, the mark in the home region, like currently if we see the home region is India for us, for example, you can file the trademark when the Indian application is already registered and then you proceed for filing in the US, for example. Or if the trademark application is pending, in that case also you can file and approach the foreign jurisdiction for that particular IP right, be it patent or trademark, anything. There are two main ways of filing a trademark application outside India. One is the Madrid Convention and one is the Paris Convention. So within depends on the strategy actually. When do you file Madrid, when do you file Paris? So if you have a particular mark, okay, and you have multiple regions to file with, you generally go for Madrid application. But the downside of Madrid application is that if your home application, like for example your Indian application, is refused, all the other application directly stands cancelled. So that's a big risk factor. And to prevent that, okay, if you're very unsure that okay, maybe it's a risk factor that other regions are getting cancelled, in that case you go for Paris Convention. In Paris Convention, you file it as an independent application. So if you file a application in India, within 6 months you file it in individual countries, say US or EP or China or Japan. So if any one of the application is refused, it will not have an impact on the balance applications. So that's the beauty of strategizing where to file under which route. So just example, Micromax has filed international applications in all the parts of the world. So the CEO of Micromax says that Madrid system is the biggest enabler for business. It gives us global reach and covers about 80% of the world trade. So a lot of foreign MNCs are opting for Madrid system because they see some kind of value to it. So Madrid Convention, now what is Madrid Convention? So it has about 130 member countries as of 2023. This is the reason why people go for, because you need to be a signatory to Madrid application or Madrid Convention, so that you are able. So there are some countries which are still not a part of Madrid. So in that case, you directly opt for Paris Convention. Means you directly go and file in those countries. You cannot opt via Madrid Convention. Madrid Convention is like a single application used to file trademarks in multiple jurisdictions. You don't have to go and file individually in those jurisdictions. You can file one single application which will enable you to file the IP in multiple jurisdictions, because it is administered by WIPO, World Intellectual Property Organization, which is based in Geneva, Switzerland. The headquarters is present there. So it's a centralized management system for trademarks. It is very cost effective and it is very fast. So, if you have a trademark application in, for example, different languages, you have to translate it in those particular regional language in order to file application under the Paris Convention. But under Madrid, you don't have to translate it. You file it only in one particular language. So if you picked up English, for example, you file it in that particular language only. So basically, it will save you cost of translations in multiple jurisdictions. Take trademark protection in all the member countries, selected countries of choice based on the business expansion plan for effective brand management and commercialization. So in Madrid application, you pick and choose the countries of your interest. You check mark those boxes where you need to file the application or where you intend to file the application. So there are various steps of trademark application under the Madrid Convention. So first you file the application with the Office of Origin, and then which is like the WIPO, World Intellectual Property Organization, and you basically have a tick mark, like a checkbox. You select the number of countries of your interest, and accordingly the fees is also determined. So there is a base fee basically, and there is a country fee. So basically, if you select, for example, 2 countries, you have to just choose those 2 countries, and accordingly the examination. So basically, examination is done by WIPO first, wherein all the procedural part is complete or not. Is there some kind of irregularity in filling the form? So they will do the correction, and then the registration is done by WIPO, wherein the publication is done. In publication, they basically publish in all those geographies where you have selected those territories, and WIPO will inform to the members countries. For example, you have selected 2 or 3 countries. Say 3 countries. So WIPO will notify it in those particular 3 countries, and then there's a timeline to it. So basically, within 18 months of its publication, okay, if the individual regional office has no objection to it, automatically you will get a registration in that particular geography. So if within 18 months, if there is no particular objection, you get a registration. If there is an objection, obviously there is something called as provisional refusal. In that case, you need to hire a local attorney of that particular region, and then you can you do the prosecution part or examination part, so on and so forth. So only the beauty of Madrid application is you can just hire one attorney and file it in multiple countries. If you have selected 5 countries, and say, for example, just say that 4 countries, you get acceptance directly from the regional offices, you don't need to hire a local attorney in that case. You save the cost of hiring a local attorney in that particular jurisdiction. Only, for example, in one country, you face some kind of provisional refusal. In that case, you hire a local attorney, and then you do the provisional refusal examination report, and then the hearing, and so on and so forth. So basically, you have saved the cost of 4 jurisdictions, local attorneys, and you don't have to pay for all the 4 of them, like all the 5 of them. Only for one you have to pay. So the cost is majorly saved in Madrid application. Generally, Madrid is filed when you have 2 or more countries of your interest. The more the number of countries that you're filing, the better the Madrid application is cost-wise. So this is the Paris Convention for trademarks, which is a convention priority. So it provides the right of priority on the basis of trademark application filed in one of the countries of Paris Union. So as I said, within 6 months of filing the trademark in a member country, which is like, for example, if you file it in India, first, within 6 months, you have to compulsorily file under the Paris Convention. If you fail to file it within 6 months, then the application in that particular geography will be considered as a fresh application, not having a priority of Indian application. So if you're okay with that, you can file it that way. But if you want a priority, you need to file it within 6 months. That's a rule, thumb rule. So there's the same thing about Paris Convention. Coming to some kind of statistics which the IP offices have disclosed in 2021. So as you see, the world trademark filing activities, 65.4% of all the trademark filing activity is having, IP offices of China, US, Iran, EU IPO, which is the European Union, and India. So out of the top 5, China alone is accounting for about 52% of the global trademark filing activities, and majority of them are the Chinese residents. So, and the remaining four has been residents of US, Iran, EP, and India. So this is just statistics of 2021. Again, so this is the amount of applications China has filed. It's about 94 lakhs, 54,794. So basically, this is the amount of applications China has filed in 2021, followed by US and Iran in EU IPO, and India comes the fifth. So this is the top 10 filers, offices, which is accounting for 76% of the total world applications for trademark. Which countries are the biggest users of Madrid system? So as I explained you, Madrid has some benefits, and majority of it is of course the benefit. Only the downside is that if the home application is abandoned, everything else falls apart. So US is the biggest filer of Madrid application, followed by Germany, China, France, and the UK. And of course, India doesn't really file much of Madrid because it doesn't stand in the top 10 filers according to the 2021 and 2022 studies. So now the thing is, why do you file Madrid, and what is the benefit of filing a Madrid application? So as per the report by IIM Bangalore, Madrid system is relevant for companies planning to export their products or services. Early brand presence abroad using Madrid system generates increased franchising opportunities. So you might be feeling that, okay, fine, I'm filing Madrid application in 10 countries, but I'm not going to go and do business in 10 countries right now. So maybe I might think of franchising my products or franchising my services. Kevinters is one of the classic example. Kevinters is present in majority of the countries and working on a franchisee model just like Starbucks. So even if you don't have business model to go and manufacture there or do direct supplying over there, what you can do is you can at least go for the franchisee model, wherein your brand name will be used in that particular geography, and you can have a arrangement with those kind of franchise agreements people, that okay, fine, I'm willing to license this kind of brand name in your geography, are you willing to manufacture it there? So this is the major scope that I see why you should file for Madrid application. Early brand presence abroad also opens up possibilities of partnering with international entrepreneurs for optimizing life cycle development and facilitates integration to global supply chains. So basically, it's like a entrepreneurship opportunity for even startups, for that matter, that even if you are not doing it yourself currently, no problem, you see some kind of value by partnering up with certain kind of people or getting some kind of investments, and your IP will be used that time. It will really escalate the brand value of your product. It will give you some kind of benefits with respect to even patents. Coming to patents, so now I think we're done with trademarks. Just to move to the next step, which is patent. So even in patents, there are two kinds of system. One is the Paris Convention and one is the Patent Cooperation Treaty, which is called as PCT in abbreviated form. So in the trademarks, we had Paris as well as Madrid. In here, patents, we have Paris versus PCT. So PCT, okay, so coming to Paris Convention. So Paris Convention will give you 12 months time to decide in which country you want to file the patent application. So for example, if you file a application today in India, if today is 21st, so 21st of October 2023, you're filing application in India within 12 months, say 21st October 2024, you need to file the application in that particular geography, or for example, say UK or say US or EP for that matter. So 12 months timeline is given to file the application in the foreign jurisdiction under the Paris rule. PCT, on the other hand, you have to file the application within 12 months. That is a strict timeline, but you get 30 months to pick and choose the countries of your interest depending on the commercialization value, or if you have found some kind of arrangement over there for commercialization or export, depending on your so right now, if you're not really sure which countries to file for the patent, and you need some time for that, of course, then you go for a PCT application. But if you have really made up your mind that these are the 5 geographies I want to file my patent, then you should go for Paris Convention. And if you're not sure, and if you want to even delay the cost of filing in those 5 geographies, then you go for PCT route, because that will delay. I'll explain you how it is being delayed. So this is a Paris Convention route. It is, as I told you, so this is the 0 months, which is like the first local filing application. In this case, if we can consider it India, within 12 months, we can pick and choose the countries of our interest and file the applications abroad. So Paris Convention is also very strict with respect to the timelines. 12 months is a strict timeline. It cannot be delayed further. For the Paris Convention of Trademarks, it was 6 months, and under the patents, it is 12 months. So just be careful with the timeline and don't get confused, please. Under the PCT route, so now this is a very beautiful timeline kind of diagram, which completes the whole of system, and which completes the whole ideology of how to file under what timeline. So this is the 0 months in which, for example, say in India, you file the application, and within 12 months, you file a PCT application. Okay. So in 16 months, once the application has been filed, there is something called as international search report and written opinion. So you can opt for international search report, and then within 18 months from the first filing date. So for example, if today, if you're filing it in India, in 12 months, you file a PCT, and within 18 months, so say 1.5 year, you file international publication. So you in 18 months, you get an international publication. That means your patent has been published. And then in 22 months, you can request for supplementary international search. And so this is a very optional procedure. You can opt for it when you want to. And in 28 months, so for example, just say 6 months after that, supplementary search report you will get. So you request the search report, and then in 6 months you get the search report. And at the 30-month deadline, you need to enter the national phase. So now imagine you get from zero, you get 30 months to basically delay your expenses. So you don't have to pay the cost of filing the application there and there itself within 12 months. You are delaying it straight to 30 months. So that's the beauty of PCT application, that you delay the cost and you delay the selection of your countries. So generally it is used by companies who are not sure that which markets are important for their value, or which markets are important for their commercialization, or if the product will work in that particular geography. I'm not very sure right now. So I will do some kind of market research. I will do some kind of analysis by which I will come to a conclusion that, okay, now I know I can do business in China. Now I know that I can do business in Australia. So I get a proper timeline of 30 months to do that analysis, to do that, valuation. And in 30 months, you pick and choose the countries of your commercial interest and file the application. So after filing, so in some countries it is 30 months, but in some countries it is 31 months. There is a list obviously given where you need to file it in 30 months and where you need to file it in 31 months. And depending on that, then the normal examination procedure will help you understand that it is novel or not, it is inventive or not. So then the procedure is as good as Paris Convention, that normal examination will happen. If they find some objections, the government will cite those objections. You need to comply to that, and so on and so forth. Then the grant will happen. So this timeline is very crucial if you want to go for a PCT route. And you need to be very much vigilant with respect to filing in those particular countries, because even like 2 days delays or 5-day delay is not gonna help you. So one client came up to me and they said that, okay, I have filed application in India. Now I want to file it in US. I said, what was her timeline? So then we checked the timeline, and she was late by 4 days. Can you imagine? Like, she was just late by 4 days, and now you cannot do anything, because this is very timeline bound things. Like, you cannot delay it by even 1 day for that matter. So please be vigilant when you need to file it outside India. So this is the same thing that I explained you in the format of flowchart. So this is an overview of the PCT system, wherein there's an invention. And if you want to file an international application, how it is filed with the help of PCT system. So international applications are first filed with the receiving office. So in this case, WIPO is a receiving office, which is located in Geneva. And then you transmit. So basically, first you file it in your home country, and you can file it. So India, you can file it via PCT route. And then once you do all the documentation part, it will give your application to WIPO, which is the International Bureau. And then they carry out the search, prepare the written opinion, and transmit the reports. So you get to know that where you stand exactly, whether your idea is really novel or not, whether it is really inventive or not. Depending on that, you can take a call whether to proceed ahead for filing in those particular geographies or not. So once WIPO publishes, so this is something called as patent scope, on which your data is being published about the PCT application, and then the designated offices like the national offices where you have chosen, you have tick marked those boxes where you have chosen those geographies. It is the designated offices come to know about your application that has been filed, and then it will do the examination, then it will grant the patent. So this is the overview of the PCT system. Coming to the statistics for patents, so this is a 2023 database, which is a very latest database. So China is accounting for 46% of the world total application. They are the almost biggest filers with respect to global patent filing data. So more than 85% of the application in 2021 occurred in IP offices of China, US, Japan, Republic of Korea, and the EP. And the majority of the stake, as I said, was belonging to China. But of course, in India also now there is a lot of, we are obviously developing with a lot of things, and the timelines have been very small now. Earlier, the patent used to take like, say, 4 or 5 years. Now you get the patent grant in 7 years, 7 months, sorry. So my personal track record has been like 7 months, in which the pharmaceutical patents, the IoT patents has been granted. So there was where was its highest patent activity? So again, I said China is amounting so and so number of applications, followed by US, Japan. So these are the top 10 countries, in which India stands on the 6th rank. Top technologies for the PCT application in different countries. So now, what are the domains in which people are filing patent for? So there are different domains mentioned: computer technology, electrical machinery, apparatus and energy, digital communication, medical technology, transport, measurement, audiovisual technology. So China is the first with respect to computer technology. It is third with respect to electrical machinery. Second with respect to digital communication. So what I'm trying to say is, this data will help you understand what is a technology trend in particular geography. So US is also the first in computer technology market. Japan is the second with computer technology. So when the top 5 were analyzed, they found out that these are the major regions in which, or the major domains in which the IP was filed. So Germany is the first in electrical machinery, and second in transport, third in measurement. Japan is the first in electrical. So depending on which domain you want to file your innovation, you pick and choose the countries of that particular interest. So if you want to file something with respect to computer technology, you will opt for China and US, because they are pro technologies. I'm not saying other countries are not, but they are good at filing, good at giving, grants of that particular domains. So even computer algorithms and softwares. So India is not really pro at giving software patents, but US is definitely a pro at giving software patents. So PCT allows the patent protection in its contracting states. So PCT now has 157 contracting states. So just like Madrid, PCT also has some kind of it's basically community in which the people enroll, the countries enroll, and those particular countries are following a particular protocol that we will examine the application in a certain manner within a certain timeline and all of that. So these are the states, which countries which are bound by Paris Convention and not PCT. So these countries, the list, if you can just see it, they are the members of the Paris Convention, but they are not members of PCT. So, the point of the matter is, tomorrow if you decide to file, for example, a patent application in Lebanon, and you might think I have 31 months to file it in Lebanon after filing PCT, but sadly, Lebanon is not a part of PCT. So you have to file a Paris Convention application, which is within 12 months compulsorily. Otherwise, you lose a priority date. You cannot file it later on. So please ensure that whatever geographies you want to select is a part of PCT or not. If it is not a part of PCT, you will have to file within 12 months. If it is a part of PCT, you can delay it for 30 months or 31 months, depends on the geography. So that's the strategy to decide how to file, when, what, when. File an international patent based on the technology. As I told you that there are different domains and different geographies which are responsible for granting certain kind of innovation. So if your company is dealing with AI technology and your business model is a function of a population, as we know, India and China are the first and second largest populated countries. This would be the market to file the foreign patents. So if your technology is dealing with function of population, then these are the geographies. If it's a part of, for example, say machine learning, then you file it specially in Japan. If it's a pharmaceutical, then you first file it in the US, because pharmaceutical, there are certain claims which are allowed in US which may not be allowed in India also. So depends on what is your domain, you pick and choose the geographies, and depending on the domain. So if your business model is based on population density and your business model is a function of per capita income, so basically per capita income means if it's a affluent market, then you file it in Europe, because as this kind of patents will work well in European region. Then you file it in that particular geography first. But generally, a lot of companies, they opt for 5 countries, which is like Europe, US, UK, China, Japan. So basically these are the major countries in which any technology driven person will file it in those countries. When majority of the business, approx 60% is coming from China, India, Indonesia, Europe, and United States, then the patent application in these jurisdictions would capture the majority of the company's revenue. So depends now what is your company's product or services. Depending on that, you have to select these jurisdictions, because this will capture the majority of the company's revenue. While deciding on securing the patent rights in foreign countries, it is significant to consider the business, the technology involved, and the return of investment from a particular geography. So blindly filing something in a foreign jurisdiction just because you have decided to file, for example, in top 20 countries, that's not going to help you, because what is the return on investment I will be getting after filing the patent? Because patent is an expensive affair, and especially foreign applications anywhere between, say even in Japan is an expensive country. So you need to really understand the market value, you need to understand the return on investment, and based on that you select the particular geography. So it is important to consider business perspective in order to commercialize the patented technology. Strategies to decide the, so you need to basically understand with your patent attorney, with your, you can pick any law firm which is specializing in IPR, and that will give you advice on the patent timeline, the procedure, which geographies to pick and choose, how to strategize this, how to commercialize it, how to monetize it, if there is some kind of infringement, how to practically enforce in those particular geography. So giving you a classic example of software. So in India, if you file software patents, so software per se is not patentable in India, but software, if it is embedded in a hardware, that is patentable in India. But in US, it's not the case. Software per se is patentable in US. So you need to really sit down with your patent attorney, and you can decide upon the technology that you are planning to venture into, and then pick the countries of your interest.
So my question is again with respect to software patent, as you said, it's if it's embedded in a hardware, then it is patented.
Correct.
But do you get patent for the entire product along with the software?
Entire product as in the hardware component?
Yes, the hardware along which where you have the software also embedded in it.
Yeah, you can patent it that way, yes.
So software and hardware both get patented.
If it is integrated, and if you show that that particular software runs on this particular hardware and it's an embedded integrated component, then you can patent it in India.
Okay, okay. That is one question. My second small question is with respect to 1 minute, I'll just tell you. Shape of goods under trademarks and the shape under design. So
Correct.
what I understand is when you are registering under a shape of goods under trademarks, you need to show for which particular, for example, it is for aerated drinks, for water or anything. We need to define the goods for which that particular shape is registered. And
Correct.
under design, it is only the actual shape of that bottle that gets registered, if I'm not mistaken.
Correct. So
Question.
in design, only the appearance of the bottle is protected. For example, Bisleri bottle, as I give you example. Now I don't have to justify that what I'm gonna fill in this bottle.
Yeah.
It's,
Okay.
the classification system is different for just the shape of the bottle. For example, if it's a bottle or a product which is like a bottle shape, for example, you need to
Yeah.
classify it under those classes under the Locarno classification, and you can register your design. But in trademarks, you need to be specific. Where are you going to use this for? For example, Toblerone chocolate, the triangle shape, as you must have known, the
Yes.
shape of goods. You have to put it under a particular class which is for chocolates.
Okay.
And
Okay.
then you can register your shape of goods.
Okay, and one more question, if it's okay. We have a concept called first to file and first to use.
Correct.
For many countries, right?
Correct.
So now, if you're filing an application in Madrid or something like that, then we need to ensure, I think, so that where it is first to use, first to file. Like in the US, it's mandatory to use within 6 months, if I'm not mistaken.
Correct.
You have to file a declaration of use and something like that.
Correct.
So can you, yeah, highlight on that?
So under Madrid application, at the time of filing of application, it is not mandatory to show the proof of use. But once the application is registered in that particular geography, within 6 months, you need to give some kind of declaration in the US that you're using this particular product or you're using this particular brand name. Under those scenarios, individual laws of those particular regions will apply. Now, even
Okay.
China has first to file use, matlab, for trademarks.
Okay. Okay.
In India, it is first to use under
Yes.
trademarks. So there is a
Right.
difference with respect to couple of geographies, and
Right.
individual rules will later on apply to that particular region.
Okay, my last question is that with respect to patents again. So, as you said that when you're filing under PCT or under the other convention, we need to file it within 6 months from the date of filing in the home country application
For trademarks or patents?
for patents.
Okay, patents, yeah. So
Yeah,
patent is 12 months, not 6
12
months.
months. Okay, so within 12 months, you're supposed to file in that. But is it mandatory to file in the home country? What if I am not going to use that invention in my home country? It's going to be used outside India only, for example. So what, like, do we have to mandatorily file in India then?
So in India, there are two things in this. So first you file it in India, for example, and the first provision what usually people do is they file it in India within 12 months they file it in another geography. Okay.
Yeah.
But if you want to file it in another geography, within 6 months of filing it in India, you get a dash code, like like a priority document. So that you can submit while filing the foreign application. That will take up to 6 weeks. Okay. So you need to wait for 6 weeks. But to answer your question now, if you don't want to file it in India, you need
Yeah.
to kind of give a declaration. There's a foreign filing license, FFL, which you need to file it in Indian patent office. That will also take up to 2 months. So generally, timeline is same only. You need to wait that much amount of time to get that foreign filing license, and then you can apply it in that geography directly. So
Okay.
also there are particular declarations that you need to take care of. That okay, it is not against the national sovereignty, security, it's not a threat, it's not a defense application, and like this kind of declarations you need to file, and then the government will give you permission, and then you can file it in the foreign jurisdiction.
Okay. Okay. Thanks a lot. Thanks a lot.
All right.
Ma'am, I have registered, one of my client has, means I have registered 4 brands as a trademark, and when 12 months is over. So is it possible to apply in Madrid Convention for their further application for the another countries?
So 12 months is over, then you cannot apply for Madrid.
Okay, not even Paris and PCT, right?
No, so basically you can file as a fresh application, as in like the priority date will not be matching with your Indian application date.
Okay.
So you can file it as a fresh application. Individually, you can file it in whatever geographies anytime. There is no problem with respect to that. But you cannot claim a priority date. That's it.
Okay, ma'am. And second thing is for the patent, is there any facilities for the startups? Because I got 1 or 2 queries, and they're asking for the startup certificates we have, and because of the startup certificates, we will get the government subsidies in the application fees and
Correct,
all.
correct.
Is it
So with respect to the government subsidy, so there are certain provisions under the Patent Act now, under which if you want to expedite your application, okay, then if you're a startup, if you're a small scale entity, which if you have a Udyamata certificate, or if there is a female applicant, okay, in the one of the applicant is a female, under those things you can opt for expedited examination. So if you have a startup certificate, obviously you can take the benefits of that particular certificate. With respect to fees also, the company filing fees is higher, the full entity, the large entity. But if you are a startup or if you are an MSME, the fees are significantly lower.
Okay, ma'am. Okay, no issue. Thank you, ma'am. Thanks a lot.
Right, yeah.
Okay. Pooja, in the chat, Devika is asking about recent amendments with respect to patents.
Latest amendments are like exactly what do you want to know about the latest amendments?
Devika, can you elaborate?
Basically, there was a draft guidelines which was passed. Basically, it was just a draft guidelines. It is not yet approved. So we are waiting for the official notification under which the act and the rules and everything will change. So it is not yet confirmed. So I did not talk about it because it is yet to be approved.
Okay. So Pooja, I think we are done with the query.
Yeah.
Right, there are no more participants. So, okay, so Pooja, we can end the session.
Yeah, sure. All right.
Okay, thank you so much, Pooja, for such an enlightening webinar. It was a great session. Thanks again.
All right.